Hello and welcome. Thank you for watching our presentation today. The law offices of McLaughlin & Associates and McLaughlin Mediation and Consulting focus on helping small to mid-sized businesses grow and thrive. You started your business because of your passion. Let us help you with that vision. We offer a variety of legal and human resources services. Check out our website for more details at www.ma-lawpc.com. And now, on to our presentation.
Okay, so on the trademark, it's different. So there's a connection between copyright and trademark, and it has to do with the logos themselves, so artwork. So as I told you, when you talk about copyright, it's artwork, painting. So an example of a copyright would be a t-shirt that would have like a cool image. So people have like these characters that they have in their business, right? And they're like, I want to have this t-shirt and I want to go out there and I want to get a trademark on this image that's big on a t-shirt. That's artwork, that's copyright. It's not. A logo, which is the artwork equivalent in that, has to do with something that identifies your business. So the logo that you see on that little tent, it's artwork in as much as the designer created it, but it actually identifies with my business, right? And so every time that you have any type of a logo, that's how those two go together, right? The laws will protect either side of that. It protects the name, okay? And the name is some unique name, okay? It does not protect your last name, like McLaughlin. I can't protect that because there's a ton of McLaughlins. I don't have the ownership of that. It means something like, like crazy law, or, something that's like, kind of stands out there. You can protect that name. You can protect your taglines. So we have this focused on business, protecting your vision, right? That would be a tagline that would be protected. Every business has some kind of a tagline. If you spent the time designing it, go ahead and get it trademarked, okay? And you'd be surprised, sometimes you think people have taken it, but they really haven't. A lot of times people haven't thought to trademark it. And trade dress. So trade dress is like the shape of a bottle, okay? So think about a Coke bottle, right? Coca-Cola, that's a unique shape. If you saw that, if I didn't see anything on that, I would know that that's a Coca-Cola bottle. That's trade dress, okay? You may have like the Oscar Mayer Wienermobile, right? If I saw the silhouette of that mobile, I wouldn't think of that as being like, an F-150. I would think it was like, the mobile. So if you have a really cool look like that, those are things to think about, and sometimes you don't. The time that matters is the first in time. Now, luckily with trademarks, because they're usually connected to, they actually always have to be connected to business. Normally it was tied to your website, or it used to be tied to, say, for example, marketing materials or flyers and those types of things. So usually you can track that these days. But you have to be the first in time. So when you apply for a trademark, they will ask you, when's the first time you used it? So what does it mean the first time you use it? Most people think, oh, the time I dreamed it up. I woke up one night and I was like, aha, there's my brilliant idea. That's not what it means. It means the first time you used it, someone actually saw it. So with copyright, no one's got to see it. But with trademark, it does. What's the difference? So copyright protects this, right? It protects the interior, it protects the artwork, the intangibles. But a trademark is tied to a tangible, it's tied to a service, it's tied to a good, a something that someone has. If it's not tied to a something, it has no value. So that's the first in time you have to do that, okay? You must publish it, okay? You cannot say, I had this idea and I never did anything with it. I went around to all of the markets. So this is so think about home-based businesses. People are doing their stuff at small markets. And they're like, I told everybody they knew about it. Yeah, but give me an example of what you use. I can't. That's called a specimen. When you do trademarks, they will refer to something called a specimen. It's really just the example of how you're using that. You have to have a valid specimen. A valid specimen is not my business card. A valid specimen is not a flyer that I put up. A specimen is not even a brochure. Why? I can't buy services or goods from them. However, if you think about, remember the old Sears catalogs? And they would send it around, you'd order from them. But if that's the way that the point of sale occurs, and they have now an area where you can order and you mail it in, it can be okay. Almost never does that happen now. Almost never will they accept a brochure. pretty much for a service, it's your website, and you know it's usually either your homepage or your services page. That's almost always good enough. Goods are a little trickier. So the goods have to be identified with the good itself. So imagine if I have a website and I have a clothing company, okay, and I'm doing t-shirts of various types. And on page 1 of my website, my homepage, I have the name of my business and my logo. And then on like page 12, I have like these cool t-shirts and the logo's nowhere to be connected. The USPTO will reject that. They'll reject that because it's not connected with the point of sale. I can't order it from there. So what you have to do is usually you'll go to the site where the page where the products are, and you have to have point of sale, and when it comes up, that logo will have to be connected there in some way. It's not a big deal, but the designers have to know that, okay? And sometimes they do and sometimes they don't. It's easy to fix. Like I said, you just have to know about those types of things, okay? Using it in commerce. Now, federal trademark as opposed to common law. I want to talk to you briefly in a minute about that. But if you went to the Illinois Secretary of State, you could technically get a state trademark for $5. Use your $5 and go get a cup of coffee, and do not waste that money. A state trademark does nothing for you, okay? It nominally protects you against someone in your state doing it. You're not getting a trademark because you're worried about that. You have a website and you're trying to go nationally. Federal trademarks are national. So under the law, there's something called intrastate and interstate. Intrastate means inside of the state. That's what the state trademark gives you. Interstate means across the highway system, okay? Illinois to Indiana to Wisconsin to Michigan to California to New York, okay? When you do federal trademark, you're getting it across all those states. But in order to do it, you have to cross a state line. It used to be when I started practicing, okay, the internet, I don't want to say it was in its infancy, then I would sound like, I think President Gore once made that claim, so I'm certainly not making that claim, or Vice President Gore, excuse me. However, it was not as used, right? So the internet now, no one does not have some internet presence of some sort. So therefore, what it's saying is if you're doing it on the internet and the internet covers the entire country, obviously, and the world, that's pretty much, you just got to have a website and you're done. And you can do it yourself website with 2 pages. They just have to be able to show that, okay? So the common law, again, what do you get for common law damages? Just like copyright, you get what you can prove, which, if it's a brand new company, is going to be nothing. And again, you'd have to show the connection to sales. So even if you got a cool logo, but your service is also kind of unique, and you're like, well, they're going to be like, well, where'd you get the money? Did you get it really from the logo, or did you get it from the services that you provide? So you get into this fight over it. So the registered trademark avoids that nonsense. It's because I'm going to show you in a minute what you get out of it, okay? So just briefly, the different areas. So you got state registration, Illinois Secretary of State, other states have their own. Federal registered, that's through the United States Patent and Trademark Office, or the USPTO. The Madrid Protocol applies to most countries. So most major countries belong to the Madrid Protocol. Some of their laws are almost identical to ours, like Canada, for example. Some of them are drastically different. And so when you try to register a trademark outside of the country, you have to apply here. This can be incredibly expensive for a multinational company, okay, because they'll do it per country and it adds up. Whereas with a federal trademark in the United States, it's obviously nationwide. So now, just a couple things that are not protected by trademark, which you can never do. Like I said, your last name, generic and descriptive terms, anything that is identifiable of your business. If I said, for example, McLaughlin Law Firm, no part of that's protectable. McLaughlin's not protectable, law firm is what I do, okay? In any of your businesses, if you tag on what you do as part of it, that part of it's forever gone. Even when you get the registered trademark, you have to do what's called disclaim it, which means you have to say, I'm not laying ownership to what describes my very industry, okay? So a lot of people like their names and they want to tie it to their businesses, but you can't protect it. So you got to come up with something unique and kind of that will be remembered. And don't try it too closely to your business. So for example, sometimes it can be the kind of things that you wouldn't think about, but become trade specific. So in an industry, there's like catchphrases. Someone says, I'm the first person to come up with a catchphrase of something. Probably you weren't, okay? But it doesn't really matter. Even if you were, if everybody in the industry is using that catchphrase for what they do, you're never going to be able to protect it, even if it doesn't show up as a registered trademark. It probably doesn't show up for a reason, right? So you just come up with something unique. But once you have the trademark, you can expand it into what's called a family of marks, okay? So related marks. So let's assume that I'm a financial planner, okay? And I have my trademark in financial planning only. And now I want to expand my service to include what would be traditional credit union. It would be lending, mortgage broker, those types of things. That's a family of mark. They're tied to similar industries, and I may be able to get all of them into mine. I've had many, many cases where someone had a trademark, our opposition had a trademark in one area. They really weren't in our client's sphere, but the USPTO said it's part of that family, okay? So once you can get it in one area, all your related areas, it's going to be like clockwork, and you're basically just going to keep expanding. Now, for trademarks, it's very specific, okay? So another thing is you cannot get a trademark and then lock it up in the entire world, okay? So if I'm a trucking company and I want to call myself, like Eagle Trucking, I can't now stop Eagle Accounting from being, using Eagle, because that doesn't do any good, right? I mean, I have it for the trucking, and if Eagle Accounting comes in there can be two Eagles. Because why? There's no confusion. That's the standard. Are two consumers going to consider it the same thing? No, they're not going to be confused between Eagle Trucking and Eagle Accounting, unless Eagle Accounting is really bad at accounting, in which case then they might confuse it with Eagle Trucking. That was a bad joke, right? Okay. So that's the idea, okay? So what I do when I'm putting trademark stuff together, a lot of the work I do is to, first of all, make sure your thing is unique, but also I want to make sure that your description and the kind of categories you've done, we're taking care of it. I'll try to go as broad as I can, but there's a limit to how broad it can go. And so a lot of the work that we do as we're getting registration is phone calls with the USPTO where they say, hey, we don't see that on the website that they're doing it, and I have to convince them. Perfect example of that is a military contract. So we have some clients who work with the military. A lot of stuff doesn't show up on the website because it's DoD protected type stuff. And so we have to kind of offline explain to them how the business works, and then we can get it protected in a broader sphere of things, okay? So the common law trademark that they have, so they already have it, will trump your ability to get a registered trademark, okay? So you're right, when you do the search, you have to look on, definitely if it's on USPTO, you're never gonna get it, okay? But if it's generally used. Now, I will tell you this though, I have gotten trademarks on things that were used by other companies if their marketing was really bad, okay? So a couple companies where we actually got the registered trademark, they actually had no internet presence. And so they were actually asleep at the wheel. They really didn't even pay attention, and we got it. And I'm gonna talk to you in a minute about how long, when you have it after a certain period of time, you actually knock your competitors out of the box. Other situations have happened, again, where they were actually there. Sometimes the examining attorneys, that's what they call the attorneys at the USPTO, look at it. They actually don't look at it. So it's like even in a court, you get stuck with somebody, and sometimes you get hit with a stickler. I mean, I always love the ones that are like Harvard grads and are like the smartest in their class, and then they're quoting trademark law to me, and they can be completely different areas, but they're like doing it by the book. But then you could have the same set of circumstances with somebody else who's like been doing it for 20 years and they don't care, and they're like, it looks okay, and then they'll give it to you. So yeah.
So when they have secured the domain name, if they're not exercising it in commerce?
That counts. So that's changing. Domains used to fall under what's called the ICANN laws. They now merge together. You have a violation of ICANN, you actually end up now having a violation of trademark. So if they have it in their domain name, you have a problem. And so because it has to do with the confusion, now we're not doing like a ton of detail on the nuts and bolts of trademark, but know this, the confusion is the number one thing they're looking for, and dilution of a trade name. If I'm using a domain, that redirects traffic, right? That dilutes its value. It also confuses. And so, yeah, you have to be very careful. So when we do searches, we're looking for it being used. We're looking at it in domain names, even ones that show up on like Manta, those things. I mean, sometimes people lock them up. I mean, there are companies, for example, in China, that's all they do. They'll lock up those names, but you have to be aware of it. It's not to say that we won't go for the registration. We just warn a client, hey, by the way, we saw this, but to your point, I think we can do it. So, you know, you just have to be aware of what it is. You know, our job is just to warn and let people know. And for the price of a trademark, sometimes it's worth it for the price of doing business. I mean, you're not paying tens of thousands of dollars to get a trademark. I mean, sometimes you're like, you know what, if I can get it, great. I'll tell you where it gets tricky is the symbols on the logos. There's a way of searching in the USPTO site that is not, it's not obvious to the average bearer. So you got to go in and you put combinations of symbols. And for example, if someone's got a star in their logo, we have to find every similar star to see if it's worked, right? Because if you have an image that's similar, for all I know, it could be tied to something, you know, in a comparable industry. And so sometimes you don't know what you don't know, and so you got to do, you know, exercise extra due diligence. The trademark law, so the Lanham Act is what it's called. So the Lanham Act, and I have the citations here for you guys, and I really just kind of highlighted the key areas if you're interested, and these are the bullet points. It has to do with willful infringement or counterfeit. It's true but not true, okay? You can sue somebody for straightforward infringement. If I have a trademark and someone tries to use it in that same industry, it's infringement. The willful infringement is not whether there's infringement, it's the kind of damages you can get from it, okay? Willful infringement, again, if you just simply think about a willful child, one who knows the rules and they violate anyway, I'm trying to get away with it, you can't correct me. It allows the judge to penalize them even though they're not supposed to penalize them. Whereas let's say it was innocent infringement. So there could be situations where they thought they were allowed to keep using it for a period of time. Or they seem different industries. I was telling you that situation where you actually technically violated without knowing it. You know, you had like a banker and you had someone who was doing mortgage broker, and they're like, well, we're not even going after the same customers. So it's possible a judge could say, you know, you did violate it technically, but it wasn't willful. So, you know, that gives them some ability. And that's why that third category there says a judge can reduce it if it turns out being a penalty. So if the true damages were $2,000 and they get hit with the $2 million judgment, you know, that would be excessive if there's no basis for that number, right? But here's what you can get. So it's 3 times your sales minus your cost, okay? I avoided using things like gross profits and net profits. We're not talking about what you report to the government, right? If we're smart, right? If there's any accountants in the room, maybe you might want to show no profit, right? Okay, so obviously your profits are going to be 0 or close to it if things are done right. So we're not talking about that. We're talking about what kind of sales are you getting and the cost of goods sold, okay? So if I have a 50% markup on my goods, okay, that's actually my profit, okay? Of course, I paid for maybe the underlying, you know, part or whatever itself. But if whatever I'm really seeing, even though I have all kinds of write-offs, and at the end of the year, I'm showing no income, that's not what they're talking about. Like, what are you making? Why does that matter? Because those profits, if you know what we would consider kind of our gross profits, are being made by the other person. They've earned money on you, and that's why it matters. So how could I penalize somebody if I get held to a tax return that shows 0, right? And you can get your reasonable attorney's fees. And again, like all these statutory areas, reasonable is really high. I mean, we're not talking about $1,000 or $10,000. We're talking about hundreds of thousands of dollars, sometimes millions of dollars, and not on big companies. So when you have the trademark, you can go after them. If they don't, it's a huge risk for them. Now, it doesn't mean that you're not paying money all the way. And so you're like, well, why would cases settle if I'm going to get my attorney's fees? Because for us, and most attorneys who do it, it's all done on an hourly basis and you get them after the fact. So you use the threat of fees to obviously get people to stop using it. Most times, when you have a registered trademark, people will stop using it, but occasionally they won't, okay? And it gets into that first in time thing. So we have situations from time to time where we ended up getting the registered trademark, you know, Adam, back to your question, which is someone actually used it earlier, but we got the registered trademark anyway. We can't go back now and tell them to stop using it, because they had a right to continue using it. But we do have protections as the registered owner from them going beyond what they have, okay? So they can still infringe, but it just changes the landscape a little bit, okay? Or, so you notice the other one had the or too, or your statutory damages of $1,000, so there's always these nominal damages you're gonna get, startup type of a company, to $200,000, okay? That's pretty good. Okay, again, it's judge's discretion. or up to $2 million for willful counterfeiting, okay? So willful counterfeiting, I've had a handful of cases that have, like NFL, that's pretty much the number one ripoff. People will take the NFL logos or any sports logos, and they will put them on their products, and they will sell them on Amazon, eBay, those types of things. If you are an e-retailer, you know how hard they come down. They're really, really strict with the trademarks these days. And if there's any element of counterfeiting, they will shut you down immediately. No questions asked, and it's hard to get it back. If all you do is e-retail or significant amount, any threat like that is a big deal. But look at those damages. If you're really counterfeiting, those are some huge damages. And if the counterfeiting is usually for big companies, right? You know, like if I take the Nike swoosh, to use that as the example before, but instead of the Nike swoosh, I decide to make it look like a music symbol, right? You know, like the little circle thing, like the quarter note. It's the Nike symbol, right? Just because I played with it, I counterfeited it, right? I made it look. I think there's actually a famous one where they have like the Michael Jordan, he's going up like this, and someone turned the angle. I didn't counterfeit that. Yeah, you did. It looks like Michael Jordan, you know, palming a basketball. So unlike the copyright, which has this long time period, trademarks are shorter. So why would that be? Well, in the artistic world, the creator of content is the one and only, right? That's why you would have their lifetime, because you want to have 70 years, right? That artistic content's not going to be reproduced. But because trademarks are tied to industries and businesses don't last for 70 years. They don't last even lifetimes, right? They could last 2 years, 3 years, 5 years. So when you have a registered trademark, between the first 5th and 6th year, you have to renew it. Between the 9th and 10th year of it, you have to renew it, and then every 10 years thereafter. The feeling is that if you've been in business for 10 years with this trademark, then you basically, they assume you're going to be in business for a period of time, okay? They will not second guess you. So let's assume I got a registered trademark, and this happened a lot, actually a lot of businesses like COVID just shut down businesses. They're like, I'm not doing it anymore, and so we didn't renew their trademarks. But they're not going to ask you in that window. So if I had a business in day one, I got the registered trademark, a year later, and I closed down in year 2, I'm still going to have that registered trademark for the next 6 years. That's important because what if I shut down in COVID, but then 2 years later I want to come back up? I don't have to renew it. I already have it, you see, and they're not going to second guess me. They just want to know at year 6, do I actually still have it? And at year 10. So the renewal for any kind of existing business is not hard. It's getting it in the first place that takes a little bit of extra work, okay? The big one's at point 2, incontestability. All right, big word that means can't contest, can't attack it, can't say it's not my trademark, okay? That is gold. Once you have incontestability, all your prior people who said that they had it before you can never say that again, even if they were there before. Why? Because it's been public for 5 years. You did nothing about it. You took no action against me. If you thought that I took your trademark, you should have done something, okay? You should have done something during the application phase, which is a notice of opposition, or you should have done something after I registered it, which is called a notice of cancellation. Those are lawsuits. They're basically saying you gave someone a trademark improperly, okay? But after 5 years, it's like the statute of limitations. It's like it's too bad. That 5-year mark is critical. So the earlier you can get it, the better you are. If you're a startup business, you register it now. If you're in business 5 years from now, you're not going to be how you were at 1 year, right? I mean, think about that. So at 5 years now, you're like, no one can touch it. No one can, and if they do, then all those things I was telling you, the penalties. And that injunctive relief that I was telling you, again, the shutdown of their using the name, it's like that, okay? And now the last part is you have to enforce it or you risk acquiescence. This is actually, that bottom part's the hardest thing to do. So acquiescence basically means you fail to police your mark, you fail to do something to protect it, okay? You let your competitors take your name. You let your competitors get into your backyard, okay? And honestly, as a business owner, I think the feeling is that if you allow your competitor to go in your backyard, that's your problem. And they're not going to penalize you if it happens in a month because you obviously have the right to enforce. But let's say that you're like, well, I don't want to spend the money to go after them. And 5, 10 years go by. At some point in time, it's going to be like, you lost it. You might keep your registered trademark, but you won't be able to enforce it against that company, okay? From my end, I have those discussions quite often. You negotiate. There are large companies that infringe that you negotiate with, and there are small companies that infringe and you shut them down, okay? But just know that if you don't police a trademark, that's a huge risk that you're going to have. They can come into court when you try to enforce it, and the judge can make a ruling that says you didn't police it. Their defense is going to be acquiescence, and the judge will say you're right. Now, the biggest issues I've seen with acquiescence, I had a big case that I had to do in Virginia. It had to do with a licensing issue, and many times these things play out as it did in that one, where two companies are using similar names for a long period of time. And it would seem like there might have been acquiescence. In that case, it was found that there was not acquiescence. A lot of it depends on the relationships of the parties. So when you have closely related parties working together, it's harder to establish acquiescence because it's been allowed. Whereas if you had a true competitor, let's assume that you had someone who was your absolute direct competitor. You've never had business with them. There was no licensing of the name or anything, and they take it. It's going to be easier, to fight. But on the flip side, it's going to be harder for you to say that you didn't acquiesce because it's your direct competitor, as opposed to somebody that you're working more closely with. So does that make sense how I made that distinction? Okay. So when the licensing world, when you have a trademark and you're licensing it, you have to be very, very careful. Your agreement has to be spelled out really, really well, and you have to enforce it really well.
Thank you again for watching this informative session. If you have any questions about what you just heard or want to contact us for legal or business consulting services, you can reach us at 630-230-8434 or email us at kmclaughlin@ma-lawpc.com. Have a wonderful day.